Kira, this decision is 6-3, written by Justice Samuel Alito, and it's a significant decision and a setback for the landmark Voting Rights Act of 1965, which was passed to guarantee equality in how we vote. And, of course, addressing the systemic and historic racial discrimination, especially across the South. This decision came in a case out of Louisiana involving a court-ordered drawing addition of a second majority black district in that state because of the size of the state's population. And the Supreme Court today, in this decision, said that the court violated the 14th Amendment by adding, the state rather, violated the 14th Amendment by adding that district. They used race impermissibly, consciously, to add a second district to aid those voters, and they said that is simply not allowed under our Constitution. Justice Samuel Alito didn't go as far as saying race can never be used in drawing these maps. That's something the court has affirmed before to comply with the Voting Rights Act, but he put a significant new limit on how courts can order states to draw their maps to be more equitable. He said that Section 2 imposes liability only when evidence supports a strong inference that the state intentionally drew its map to discriminate. So a setback for minority voters in Louisiana. And now, Kira, the impact of this decision is going to start to ripple across the country.
Let's talk about that impact and bring in our legal contributor and law professor at Hofstra University, James Sample. I mean, James, this is clearly, gutting landmark legislation here.
Absolutely correct, Kira. This is a ruling that almost completely constitutionalizes a color blindness principle to the point that even race-conscious remedies designed to remedy racial discrimination are unconstitutional under the very amendment.
What happened?
Well, some think that the ruling can create more Republican-held congressional seats in the South.
That's good.
Yeah,
that's the kind of ruling I like.
What happened in Washington was not just another court ruling. In a 6-3 decision, the Supreme Court struck down Louisiana's second majority black congressional district and sharply narrowed how Section 2 of the Voting Rights Act can be used to challenge maps that dilute minority voting power. Within hours, Chuck Schumer was on offense, calling the ruling a historic rollback and launching what he described as Democrats' biggest election protection push yet. And then came the line that turned this from legal story to political firestorm. Donald Trump praised the ruling as the kind of ruling I like. That is the moment this stopped being a court story and became an election story. The legal case is Louisiana versus Calais. The court's majority said Louisiana was not required under the Voting Rights Act to create an additional majority-minority district, and because of that, the map was an unconstitutional racial gerrymander. But the real shock was not only the outcome, it was the standard the court introduced. The majority said Section 2 now applies only when the evidence strongly suggests a state intentionally drew districts to reduce minority voting power because of race. That is a much steeper bar. Justice Elena Kagan, reading from the bench in dissent, said the court's so-called updates to the law actually eviscerate it and amount to the demolition of the Voting Rights Act.
The Supreme Court has struck down Louisiana's second majority black congressional district in a decision that could boost Republicans' balance of power in Congress. The High Court finding that the Louisiana redistricting relied too heavily on race and snaked districts to create districts favorable for Democrats. The decision weakens a landmark voting rights law protection against discrimination in redistricting. It's not clear whether the decision was issued early enough for some states, including Louisiana, to consider a new round of redistricting ahead of the midterms, in which Republicans are trying to preserve a thin majority. Several states right now are in the spotlight because of redistricting. Florida, for example, set to vote on a new proposed map here soon.
It does have major implications for who controls the House of Representatives, which party controls the House of Representatives, and perhaps just as importantly, minority representation in the House of Representatives, in particular, African-American, Black American representation in the House of Representatives. Now, in Louisiana, they cited the Section 2 of the Voting Rights Act, which incidentally, the Supreme Court has now let stand, and that's the compromise here. But they looked at that district in particular and said it violates the gerrymandering principles. In other words, it is so convoluted, so distorted, this district, in an effort to draw that second majority-minority black district in Louisiana, that it violates the law.
A Supreme Court decision, which was a despicable decision, that is a return to Jim Crow.
Schumer's language was not accidental. He wanted to move this out of the courtroom and into America's long civil rights memory. When he says Jim Crow, he is telling viewers this is not a technical fight over district geometry. He is saying this ruling could reopen the door to maps that dilute black political power while looking clean and legal on paper. And that argument is not coming from Democrats alone. Reuters reported the decision could clear a path for Republican lawmakers to target Democratic-held districts with majority black or Latino populations across the South. Politico called it a decision that adds uncertainty and could trigger a redistricting scramble. In other words, the fear here is not symbolic, it is structural.
I think of it as a mob term. I don't know, people think of it as something having to do with disappearing, but the mob uses that term to say when they want to kill somebody, they say 86, the son of a gun. I'm trying to keep the language nice and clear. They don't use that term, son of a gun. They use another term. But that's a mob term for kill him. Yeah.
But do you really think your life was in danger?
Probably. I don't know. You know, based on what I'm seeing out there, yeah. The people like Comey have created tremendous danger, I think, for politicians and others. Comey is a dirty cop. He's a very dirty cop. He cheated on the elections. He tried to help Hillary Clinton, as you know. He dismissed a lot of things that he should have proceeded with. I wasn't involved, but he should have proceeded with. No, he's a dirty cop. He's a crooked man.
This may be the most revealing part of the whole story. Trump did not react like someone studying a constitutional ruling. He reacted like someone seeing a political opening. In the AP clip, he says the decision is the kind of ruling I like, calls it a win for Republicans, and suggests states should think about redrawing maps. That matters because it collapses the legal debate into a plain political reality. The side cheering this ruling believes it can help shape the battlefield before voters ever cast a ballot. And once that becomes the public message, Schumer's next move makes more sense. He was not merely condemning the court. He was trying to organize a counteroffensive before the map fight spreads.
I do want to get to some breaking news with the Supreme Court, and I did want to share this with you right here. The breaking news that the Supreme Court has struck down a majority black congressional district in Louisiana, weakening a landmark voting rights law's protection against discrimination in redistricting. And I did want to share just a little bit more information as we continue to follow this breaking news coming as we were sharing that live hearing with you with Secretary Hegseth. The Supreme Court limiting the scope of a key Voting Rights Act provision that restricts how states draw districts affecting minority voters, constraining states' use of race as a factor when drawing congressional maps ahead of the 2026 midterms. Justices for the 6-3 majority ruled that Louisiana's newly redrawn congressional map, which created a second majority black district, constituted an illegal racial gerrymander. The justices did acknowledge that compliance with the Voting Rights Act can be compelling interest for states, but they ruled that it did not require Louisiana to create the new map with a second majority black district. Compliance with Section 2 of the Voting Rights Act, quote, as properly construed can provide such a reason. That is what Justice Samuel Alito wrote for the majority, saying, quote, correctly understood, Section 2 does not impose liability at odds with the Constitution, and it should not have imposed liability on Louisiana for its 2022 map. Adding compliance with Section 2 thus could not justify the state's use of race-based redistricting here. While the ruling does not override overturn the Voting Rights Act or Section 2, it is likely to narrow how minority representation influences multiple states' congressional maps and trigger a new wave of legal challenges over congressional boundaries. That case was first argued last March before the Supreme Court and centered on whether Louisiana's 2024 congressional map, which had added a second majority black district, amounted to an unconstitutional racial gerrymander. So we are continuing to follow the very latest developments. And we also have this from Chad Pergram saying from colleagues Shannon Bream and Bill Mears, the Supreme Court has tossed out a revised Louisiana congressional map that added a second black majority district, a voting rights ruling that could have major political and social implications in future federal elections. The timing of the 6-3 decision along ideological lines authored by Justice Samuel Alito, which we did quote right there, may limit impact on other redistricting efforts in a time to affect the November midterms, with several states already beginning early primary voting. And I also wanted to share this with you as we are also continuing to watch other rulings from the Supreme Court. These are just three main points right here that we wanted to bring to you. The first is that the court unanimously sided with Faith-Based Pregnancy Center challenging a New Jersey investigation of its practices. As we also mentioned, the court ruled Louisiana's congressional district is unconstitutional gerrymander, limiting a key tool of the Voting Rights Act. And also the court will hear arguments today on ending legal protections for Haitian and Syrian migrants.
To understand why Democrats are treating this as an emergency, you have to zoom out. For years, critics of the court have argued that voting rights protections were being chipped away piece by piece, starting with Shelby County v. Holder, the 2013 case that weakened the federal government's power to block discriminatory election changes before they happened. Section 2 was one of the last major tools left for challenging minority vote dilution after the fact. Now, according to the court's critics, even that tool has been narrowed to the point of near paralysis. That is why Kagan's dissent sounded less like routine disagreement and more like an alarm bell. And that is why Schumer immediately shifted from outrage to organization.
Which would disenfranchise 20 million people. And we are fighting that every step of the way. And as I said, today we're ramping up our efforts. And what are we doing? We are joining with forces with outside groups that have been working on this as well. And the outside groups that are the people who will be joining us at our meeting are Eric Holder of the NDRC, Mark Elias of the Elias Law Group, Wendy Weezer of the Brennan Center, Vanita Gupta of NYU Law, Justin Vale of Protect Democracy, and Jody Morse of Democracy Forward. We are looking at election threats to integrity of our election and our election process up and down the line. We're looking at election administration threats. We're looking at the kind of bad play and horrible things that could come out of DOJ and DHS. We are looking at attacks on free speech and the independent media. We are looking at foreign threats. We are looking at militarization of law enforcement and corruption. We are looking at in making sure that in any of these areas, the right to vote, the fairness and integrity of our elections is protected. And so we're ramping things up by dealing with these groups in our sort of task force on election integrity and protecting.
Then came Schumer's actual announcement. He said Democrats were launching their most expansive effort yet to protect the 2026 midterms and shield them from what he called direct threats to free and fair elections. He said he would meet with former Attorney General Eric Holder, Democratic election lawyer Mark Elias, and other voting rights and democracy experts. That list matters. Holder symbolizes the anti-gerrymandering legal war. Elias symbolizes the party's election litigation machine. This was not a symbolic press conference. It was a signal to activists, donors, lawyers, and election officials that Democrats intend to fight on the terrain of maps, lawsuits, ballot access, and public messaging all at once. So here's the bottom line. The Supreme Court ruling in Louisiana v. Calais did not just redraw one state's political map. It may have changed the rules for how minority voters defend their representation across the country. Chuck Schumer understood the political danger immediately, which is why he did not stop at condemning the decision. He announced a larger election protection apparatus, surrounded himself with veteran voting rights lawyers, and framed the ruling as part of a broader fight over who gets heard in American democracy. Trump's reaction made the stakes even clearer. If one side sees this as a legal correction and the other sees it as a map-making opportunity, then the battle ahead is not only about law, it is about power. And the next phase of that battle may play out long before Election Day, in courtrooms, state houses, and the district lines most Americans never notice until it is too late.